Welcome to TFE Talks, Navigating Wealth, Business, and Legacy, the podcast from Thomas Fisher and Edwards. Each episode, our attorneys bring you expert insight on estate planning, business strategy, and legacy building, breaking down complex topics into clear, actionable advice. Whether you're solidifying a strategy we've discussed or preparing for what's next, this podcast is your resource for thoughtful, practical planning. You ready? Let's dive in.
Hello and welcome to another edition of TFE Talks. I'm your host, Jordan Goewey, joined today by Mira Prisco, an associate here at Thomas Fisher and Edwards. Mira, you joined me for an earlier podcast where we introduced you and talked about your journey from Delaware down to Clemson and then LSU and Florida and then back up here to Greenville to join our firm. This will be the first time you've joined us for a substantive topic to talk about something in the law. And today we're going to talk about something that's very important, though a lot of clients are often surprised in my experience when we bring this up with them, but it is defining children and descendants in our estate planning documents. And so I meet with clients and we talk about estate planning and trust planning. And as I mentioned, they're often surprised when I say, okay, now we need to talk about how you would define children and descendants, because clients often say, well, I know who my children are. Why does this need to be defined? So Mira, why is it important to define children and descendants in estate planning documents, especially when these could involve long-term trust or generational plans?
Right. You sort of just said it. A lot of these estate plans are meant to continue for generations. And so you're not just defining your children, you're defining who you want to inherit long-term, your grandchildren, your great-grandchildren, and even further down the line, depending on how long, let's say, your trust lasts. And so it's important that you don't just look at who your current family is, but who your future family may be as well.
Yeah, absolutely. And so even when we say that, even when we say, okay, we're defining your grandchildren and your great-grandchildren, some clients, they still look at it and they say, okay, but I'm going to know who they are, right? That's not that hard. Those definitions are pretty clear, but that's not always the case. What are some types of disputes that can arise about who is a grandchild of mine, who is a great-grandchild of mine, and so on?
Right. So in today's society, we have all kinds of blended families, adopted children, there's IVF technology. And so with those kinds of developments, those definitions become less clear. So do you want to include an adopted grandchild? What about a child who was adopted outside of the family? And so although you think you'll be able to look at a family photo and say, oh, they're all my family, the law doesn't always define family in that way.
That's right. And then in addition to that, I'll just mention that there are also people with different religious backgrounds, people with different cultural backgrounds, and they may look at things very differently as far as the type of individuals that they consider their descendants and family members. And so let's focus on a typical definition that we use in our documents, which we based on a state law here in South Carolina that actually dealt with when assets go from a deceased child up to a parent. We kind of have taken that definition under state law and made it our children and descendants definition. And we'll change it for certain clients, but from just our basic definition, how do we treat adoption, for example?
So in our documents, we treat adoption, as long as the child is adopted before the age of 18, as a child. And that's because adoption is recognized in this state as a binding parent-child relationship. It's a legal relationship. By that same kind of flip side of that, if a child is adopted outside of the family, if you give a child up for adoption, they now have a parent-child relationship with their new adopted parents. And so we treat them as not being a descendant. Part of that is to also deal with adult adoptions, and that's because inheritance, you want to make sure there's not some kind of abuse of later inheritance by adopting an adult.
Sure.
And so we cap in our definition the age of 18.
Yeah, absolutely. And I remember from law school, I think it was a case like out of Kentucky where like there was a man who realized that if he died, then the assets would go to someone else in his family. But if he had a child, it would go to that child. And so he like tried to adopt his 30-year-old girlfriend and say that she was a child of his, so that if he died, it would go to her instead. And so we try to avoid things like that. And again, these are the default definitions that we put in. We set it at 18. I have had clients that have told me, no, I want them to be adopted before age 5. I want them to be adopted before age 10, because if my child adopts someone in high school, I don't want them to necessarily be treated the same as my other grandchildren who, were with them for 18 years
Right.
as children. And so all of these things can be adjusted if needed. But again, we're kind of going through the base case.
And I think that's a good example. People's definitions will surprise you, what they want age-wise or how they want to tweak it. And that's kind of a perfect example. Not sure I would have thought of that example.
Yeah, and I'd say 90% of my clients. Obviously, I've been practicing a little longer than you, but 90% of my clients, they take our definition as it's written, but some do have very particular ideas. And another place where people can have particular ideas is on posthumous children or after death births. So that just sounds very complicated. It's really not all that complicated. So why don't you tell us exactly what that means and where that can
Sure.
arise?
So one example is if a child is conceived before the death of a parent but then born after. But another example is if, for example, in IVF, where you're using genetic material after the death of a parent and then the child is also born after the death of that parent. And this is becoming more and more common and extremely relevant in the law because it's new to everybody, and we haven't quite figured out, how that's going to affect legal documents and things, because science is still developing in real time.
Right.
And so some people want to include those children who have their genetic material if they die, if it's half theirs, even if it's born after they've passed. There's a slight issue with paternity. Some people want to make sure that it is in fact their child if they're not there after they've passed. And in our documents, I believe the child has to be born within 294 days.
Yeah, which is
around
42
there.
weeks, so
Yeah,
kind of
so-
the
right.
long end of a typical pregnancy.
But IVF and sort of reproductive technology is emerging and changing in real time. And so part of that is we need to kind of continue to develop these definitions to include what people want for those families who are choosing to use IVF.
Yeah, that's right. And again, I'll go back to, we're kind of talking about our base definition, but we can tweak that at times. And we always ask our clients in the questionnaire that we send them, do you or any of your descendants have any frozen genetic material? Because if there are specific risks as to this family, or if someone is actually, potentially planning on having a child by IVF or something like that, we want to be sure that we maybe address that more specifically or think through it in more detail, because it is going to be something that just comes up more and more as time goes on.
In law school, I had a professor who said, the law is always a little bit behind science. Science changes and it becomes, better and better. And the people who pass the laws have to kind of come after that and decide how are we going to handle it. And so IVF right now is a great example of that with how the legal documents follow after.
Sure. And so you mentioned that part of the issue with those after-death births is the issue of paternity, and that is also something that can come up with out-of-wedlock children. And so how do we approach out-of-wedlock children typically in our documents, and how can it differ between a child born out of wedlock to a female versus a child born out of wedlock to a male?
Sure. So if a child is born out of wedlock to a female, we assume the child is the mother's. We say that is the mother's child. For paternity, it's a little bit harder to prove. And so in our documents, there are a few options. One of them that's not very commonly chosen, I don't think, is that the father has to marry the mother. Mm-hmm. And that's sort of more of an old school way of how documents used to be written. Now there's sort of a more modern definition. It's that the father has to know of the child, treat the child as their own. And that kind of prevents people coming 20 years later and saying, oh, I'm the child of this man that he didn't even know I existed. And so our definition kind of, or one of our definition options kind of gets rid of that issue.
Yeah. Yeah, and I think that's very important because I think a lot of times when you look at that definition, it can look as though you're really just giving the father the opportunity to say, no, I don't want to recognize this one. But it's really more intended to avoid that situation where, our client has a son who has a child out of wedlock that he doesn't know about, and then the son dies, and then 50 years later,
Right.
someone is like, hey, actually, I was his child. And then does our client, who would be the grandparent to that child, do they really want that child to inherit the same as their other grandchildren? Often not. And so I do think that it's a good way to, again, it's all about what the client wants at the end of the day. But if they would not want that person to inherit, then I think that definition kind of gives us some of that leeway. But also just addressing paternity, as far as like a paternity test, that's important as well, because we can't tell with men as well as we can with women
Right.
whether or not it's their child.
Right.
And so that's important to have in that definition as well.
Sure.
And so this has been a really good discussion on some of the key factors that we determine or that we talk about with our clients in defining children and descendants. What practical advice would you give clients with respect to thinking through these issues? And also, are there any sort of life events that should cause clients to just review their estate plan when it comes to this particular issue?
Sure. I think my practical advice would be sort of something I touched on earlier, and it's that to look at your family and look at the definition in our documents and see, is the way you define your family the way the law defines your family? Because ultimately, if you don't have a really comprehensive definition that you like, someone else will decide, the court, the trustee, somebody later down the line, perhaps when you're not there. And so really look at how you want to define versus how the law defines family. Life events, look at divorces, adoptions, remarriages is a good example. Do you want stepchildren? So those kinds of life events really are a good time to look back, pull your documents out, and see how you've defined your family, your children and descendants, and if you want to tweak any of that.
Yeah. And one thing I'll tack on to that as well is, I think our definition is great and I think it's clear and it covers a lot of these situations. But when in doubt, put the situation directly in the document as well. Even though our document says if someone is adopted before age 18, they're treated as a child.
Sure.
If you have a grandchild who was actually adopted by your child,
Right.
put it in there that this adopted person is treated as a grandchild of mine. That way there's no question, whether it was the right kind of adoption or whether it was perfectly legal or how that works. When in doubt, actually put any of those questionable situations, put them clearly in there so that there's no debate about it later.
Right, exactly, yes.
Yeah. And so, Mira, this is always, I'd say, a tricky topic to talk about with clients because, again, they initially just don't really see the importance of it. And then it touches on a lot of things that are a little uncomfortable to talk about at times.
It can be sensitive at times.
And very sensitive as well. And so thanks for joining me today to tackle a pretty difficult topic. And I look forward to having you on future podcasts as well.
Thank you.
Thanks for listening to TFE Talks. For more information, please visit our website at www.tfelawfirm.com. You can also follow us on LinkedIn, Facebook, and Instagram by clicking the links below in the show notes. If you have any questions about topics discussed in the episode or you have recommendations for future topics, please email us at info@tfelawfirm.com. See you next time.